Imagine waking up one day, fresh from a divorce, only to find yourself shackled with your ex-spouse's credit card debt. Take a moment, let that sink in. Picture this scenario. You've just come through the emotional ringer of a divorce. You've been through the highs, the lows, the in-betweens, and finally you've reached the end. You're ready to start anew, to rebuild your life, brick by brick. But then, you receive a letter, a statement of outstanding credit card debt, and it's not even yours. It's like a bucket of ice-cold water being dumped over your head. Suddenly, you're thrown into a whirlpool of confusion, disbelief, and anxiety. You didn't sign up for this debt. You didn't swipe that card. You didn't indulge in those purchases. Yet here you are facing the consequences of someone else's spending habits. The emotional turmoil is one thing, but the financial implications, they can be devastating. You're looking at months, maybe even years of payments, a constant reminder of a past you're trying to put behind you. Each payment, a chip off your hard-earned money, going towards clearing a debt that isn't yours. And then there's the impact on your credit score, a dark cloud looming over your financial future, threatening to rain on your dreams of owning a home, of starting a business, of securing your financial independence. It's a burden, an unwanted burden, and it's sitting heavy on your shoulders. You might ask yourself, is this fair? Is this just? You've done your part. You've kept your finances clean. You've been responsible, and yet you're being punished for someone else's recklessness. It feels like a twisted game of chance, where the dice is loaded against you. A nightmare, isn't it? But can this really happen in the state of North Carolina? Let's delve into the facts. In North Carolina, the concept of marital debt is a key factor in divorce proceedings. This phrase may seem a bit perplexing at first, but let's unpack its meaning together. Marital debt, simply put, includes all debts incurred by either spouse during the course of the marriage. Yes, you heard it right. It doesn't matter who signed on the dotted line or swiped the credit card. If it happened while you were married, it's considered marital debt. This concept is rooted in the idea that marriage is a partnership, a shared endeavor, with both benefits and burdens to be divided equitably upon divorce. To better understand this concept, let's delve into some real-life case studies that illustrate how marital debts have been handled in North Carolina divorces. Consider the case of a husband who took out a car loan during the marriage. Despite the vehicle being solely in his name, the loan was deemed a marital debt during the divorce proceedings. Or take the example of a wife who racked up considerable credit card debt buying designer clothes without her husband's knowledge. Despite his lack of involvement or even awareness, the debt was still classified as marital debt because it was incurred during the marriage. Yet another case involves a couple who took on substantial debt to fund their child's college education. When they divorced, the student loan debt was considered marital and was divided between them. These examples highlight a critical point. It's not just about who spent the money, but when and how it was spent. But here's something to mull over. What if the debt was for a negative or destructive purpose? For example, what if one spouse secretly gambled away thousands of dollars during the marriage? Well, North Carolina courts have some discretion in these matters. They can consider the purpose of the debt in deciding how to divide it. So, if a debt was incurred for the benefit of both spouses or the family, it's likely to be divided equally. But if it was for a negative purpose, the court may assign more of the debt to the spouse who incurred it. This brings us to another important point. The concept of marital debt doesn't mean that each debt is automatically split 50-50. The court considers various factors, such as each spouse's income and earning potential, the duration of the marriage, and the needs of any children involved. So, the division of marital debt can be complex and nuanced, reflecting the intricacies of the marital relationship itself. So, it is clear that marital debt is not just about who spent the money, but when and how it was spent. It's about fairness, about ensuring that both parties share the consequences of financial decisions made during the marriage, regardless of who made them. It underscores the fact that in a marriage, for better or worse, in wealth or in debt, we are in it together. North Carolina follows the equitable distribution law when it comes to dividing marital property and debt. Now, you may be wondering, what exactly does this mean? Well, simply put, it implies that the court will attempt to divide marital property and debt fairly, but not necessarily equally, between the two parties. To paint a clearer picture, let's imagine that the marital debt is a giant pie. The court's job now is to slice up this pie in a way that is just and fair to both parties, taking into account a variety of factors. The size of the slice you end up with does not solely depend on whose name is on the debt. Rather, the court considers the overall picture of the marital financial situation. So, how does the court decide what's fair? It's not a random decision, nor is it purely mathematical. Instead, the court analyzes a wide range of factors. This includes the duration of the marriage, the age and health of both parties, the income and earning potential of each spouse, and the standard of living established during the marriage. In addition, the court looks at the contribution of each spouse to the acquisition, preservation, or appreciation of the marital property. So if one spouse stayed home to raise the kids while the other worked, the court acknowledges that as a valuable contribution. Moreover, the court also takes into account the liabilities or debts of each party. It looks at who incurred the debt and why, as well as who benefited from it. For instance, if a credit card was used to purchase a vehicle that was primarily used by one spouse, that information could influence the division of that debt. Now, let's circle back to the question at hand. What if you're not responsible for your spouse's credit card debt? Well, in the eyes of the court, the responsibility is not solely determined by whose name is on the bill. If the debt was incurred during the marriage and it benefited the marriage in some way, it could still be considered marital debt, and thus factored into the equitable distribution. This means that even if you never swiped that credit card, even if you didn't know about its existence until the divorce proceedings, it could still affect the slice of the debt pie you're served. But remember, this doesn't necessarily mean you'll be left to shoulder the entire burden. The court strives to distribute the debt in a manner that is fair to both parties. Your individual circumstances, contributions, and needs will be taken into account to ensure that the distribution is as equitable as possible. So, even if the credit card debt was not yours, it could still impact your financial future post-divorce. The equitable distribution law is complex, and its implications can be far-reaching. Understanding it can help you navigate the often murky waters of divorce and prepare for what lies ahead. But there are always exceptions to the rule, aren't there? Indeed, our lives are not always painted in black and white, and neither are the laws governing marital debts in North Carolina. So let's delve into the gray areas of this rule, where you might not be held responsible for your spouse's credit card debt. First, let's look at the purpose of the debt. The general rule is that all debts incurred during the marriage are shared equally. However, if the debt was incurred for non-marital purposes, it may not be part of the marital debt. But what does this mean? Well, if your spouse racked up credit card debt for a purpose not related to the marriage, such as a secret gambling habit or extravagant personal spending, you may not be responsible for it. In these scenarios, the court might consider these debts as separate and thus not your responsibility. Moving on, let's talk about timing. When was the debt incurred? If your spouse's credit card debt was accumulated after you both decided to separate, then it might not be considered marital debt. The key here is the date of separation. After this date, any debt your spouse incurs is generally considered their separate debt. However, remember, this is not a hard and fast rule, and the court has the discretion to decide based on the specific circumstances of your case. Another exception could be if you were unaware of the debt. If your spouse incurred credit card debt without your knowledge or consent, and you didn't benefit from it, the court may rule this as separate debt. This is especially true in cases of fraud or deceit. Now you might be wondering, what about joint credit cards? Well, if both your names are on the credit card, you are usually both responsible for the debt, even if one of you never used the card. However, if you can prove that your spouse was the one who primarily benefited from the spending, then you might not be held fully responsible. Lastly, let's not forget about premarital debt. Any debt that your spouse brought into the marriage is typically considered separate debt and remains their responsibility after a divorce. So, while the rule is broad, there are cracks that may provide some relief. It's important to remember that every case is unique. The court will consider various factors such as the purpose of the debt, when it was incurred, and whether you knew or benefited from it. Therefore, it's crucial to have a clear understanding of your financial situation and to be able to present it accurately in court. Remember, the goal of the court is to achieve a fair and equitable distribution of assets and debts. And sometimes fairness means that you are not responsible for your spouse's credit card debt. So while the rule is broad, there are cracks that may provide some relief. With so many variables at play, navigating through this financial maze can be daunting. The world of marital debt and equitable distribution is complex and intricate, and it's all too easy to trip up on a hidden pitfall or oversight. That's where the guidance of a seasoned expert comes in. Legal advice isn't just a luxury, it's a necessity. When it comes to matters as serious as divorce and financial obligations, you want to ensure you're making the best informed decisions. A lawyer experienced in divorce proceedings can help you understand the ins and outs of the law and guide you through the process step by step. But how exactly can a lawyer help? Well, for starters, they can give you a clear, unbiased understanding of what the law says. They can explain the intricacies of North Carolina's equitable distribution law and how it pertains to your specific situation. Furthermore, an attorney can help you compile and organize all necessary documentation. They can ensure that you've accurately accounted for all assets and debts and that nothing has been overlooked. This can be a tedious and overwhelming task, but it's crucial for a fair and equitable distribution. Beyond that, a lawyer can also help protect your rights. They can advocate for you, ensuring that you're not being taken advantage of or unfairly burdened with your spouse's credit card debt. They can also negotiate on your behalf, striving to reach a settlement that is fair and just for you. Finally, an experienced attorney can offer you peace of mind. Knowing that you have a knowledgeable professional on your side can alleviate much of the stress and uncertainty that can accompany a divorce. They can help you navigate this challenging time with confidence and clarity. So the next time you find yourself facing the labyrinth of marital debt and equitable distribution, remember, you don't have to go it alone. Seek professional legal advice. Remember, when it comes to your financial future, it's always better to be safe than sorry. Divorce is never easy, and dealing with marital debt can add to the stress. As we wrap up this comprehensive discussion on marital debt in North Carolina, let's take a moment to revisit the key points we've covered. We started off talking about the unwanted burden of debt in a divorce scenario. We learned that in North Carolina, as in many other states, the concept of equitable distribution applies. This means that marital debt, as well as assets, are divided between the two parties in a fair, though not necessarily equal manner. We then delved deeper into what constitutes marital debt. We discovered that it includes all obligations incurred by either spouse during the course of the marriage, up until the date of separation. This means that even if you weren't personally responsible for a debt, like your husband's credit card bill, it may still be considered in the equitable distribution calculation. However, we also learned that there are exceptions to this rule. Certain debts, such as those incurred for a spouse's personal benefit outside of the marriage, may not be included in the marital debt pool. But remember, these exceptions are not automatic or guaranteed. They are determined on a case-by-case basis and require thorough evidence. This brings us to the crucial need for legal advice. Understanding the ins and outs of marital debt laws can be complex and overwhelming. Seeking guidance from a seasoned attorney can help you navigate this tricky terrain, ensuring that your interests are protected. And so, we circle back to the significance of knowledge of your rights, of the laws, and of the potential outcomes. Because in the end, the more you know, the better you can prepare, and the more control you can have over your financial future post-divorce. Knowledge is power, and in the world of divorce and debt, it could be your saving grace.